الحمد لله رب العالمين وأفضل الصلاة وأتم التسليم على سيدنا محمد وعلى آله وصحبه أجمعين أما بعد السلام عليكم ورحمة الله وبركاته.
Assalamu
Waalaikumsalam warahmatullahi
Respected
taala
Ustaz Jamal,
wabarakatuh.
Dr. Firdaus, Brother Yusuf, and our brothers and sisters in Myanmar Muslim Club and Myanmar Muslim community in Singapore. Thank you so much for your time and participating today. My name is Omar. I will be the host for today's sharing session, inshallah. So before we proceed for our today wonderful session, may I seek all of you to participating with me to recite Surah Al-Fatiha to begin the session, inshallah. أعوذ بالله من الشيطان الرجيم.
Bismillahirrahmanirrahim.
الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد
وإياك نستعين
اهدنا الصراط
المستقيم
صراط الذين أنعمت عليهم غير
عليهم
Amin, Amin, Amin. So first of all, on behalf of our Muslim community in Singapore, we would like to thank Dr. Firdaus Yahya for your knowledgeable session sharing later on and for your time. Alhamdulillah. Thank you so much for accepting our invitation for today's sharing session. Inshallah, this is the first time we are meeting Dr. Firdaus in this meeting room. So before we invite Dr. Firdaus to deliver his topic, which is understanding Faraid and estate management. So I would like to take this opportunity to spend a few minutes to introduce Dr. Yahya, his biography. So subhanAllah, a few days ago, I messaged doctor and then I asked him, so could you kindly send me your profile? So mashallah, Dr. Firdaus, he replied me only 2 words. He said, I am a consultant in a company called Shell International, and then I am a religious teacher. MashaAllah, such a, humble scholar with us today. But however, Dr. Firdaus, please allow me to introduce a little bit about your profile, which is, I found it in Shell International website. So I believe most of us in this room, maybe first time meeting you, but I met you a few years ago, and then that just for their sake, inshallah. So a few years ago, I was in Al Mauri Resource Library in Dar Arkam. I was in charge in the library, and then we crossed by a book called Cosmetic Science. So it was Dr. Firdaus doctorate, I think is it your doctorate
my
paper?
doctorate thesis,
mashallah, and after that printed by IIUM. So we invited Dr. Firdaus to deliver a talk on that topic as a book sharing session. So I still remember that, Alhamdulillah. So Dr. Firdaus Yahya, he is a well-known Muslim scholar in Singapore. He is a principal consultant religious for Shell International. He is a well-rounded academic and experienced practitioner in various fields. He attained his doctorate in Islamic science and master's in prophetic tradition and sayings, Sunnah and Hadith from the International Islamic University, Malaysia in 2012 and 2005, respectively. So here he obtained his bachelor degree in Arabic language and literature from the well-known Al-Azhar University in Egypt in 1996. Just now, I also introduced Doctor to our beloved Ustaz Jamal. So Jamal, he completed his study in Al-Azhar in 60s. So before I was born, mashallah. So Doctor, today you are meeting your senior in this room, alhamdulillah.
My respect to Ustaz Jamal.
MashaAllah.
Alhamdulillah, barakallah.
So after successfully completing his GCE O level in 1990, he pursued and was awarded with Cambridge Diploma in Computer Studies from the University of Cambridge in 1994. His technical and scientific passion did not stop there. He went on to complete a certificate program on astronomy from the prestigious University of Leicester, UK in 2000. He was an executive with the Office of Mufti from 1990 to 2001 in the Islamic Religious Council of Singapore, MUIS, a statutory board and the authority on Islamic matters in Singapore. During his time in MUIS, he had completed numerous research on religious socio-economic matters. His work substantially contributed in the drafting of national policy and fatwa religious ethic decisions. MashaAllah, even one Dr. Firdaus pursuing his academic inspirations. Dr. Firdaus also was very active, involved in many aspects of the religious activities in Singapore and the region. So one of his key involvement was being an important member of the religious committee for the Singapore MUIS Halal Standard, SMHS, in 2005. His most important work on halal, however, had been his research and feedings on the guide to Muslim conception in 2004. In his work, he reviewed classical categorizations of halal food for Muslim that become a critical part of the Singapore MUIS Halal Standard, which in turn had been referred by many other national standards around the world. So his profile and researches had resulted in many invitations to seminars and conferences in Southeast Asia and Middle East. He is now a gazetted member of the Council of MUIS and Fatwa Committee of Singapore. He had also served in the board of the Singapore Religious Teachers and Scholars Association, FIRCUS, as a secretary. And Dr. Firdaus also one of the advisory asatizah in Daragam, Singapore, Muslim Combat Association, MashaAllah. So today we are very honored to invite Dr. Firdaus to deliver a topic about understanding Faraid and estate management, which is very important for our Muslim life. So without further ado, may I kindly request Dr. Firdaus to proceed for your sharing today, inshallah. And thank you so much, everyone. Dr. Firdaus, please. Thank you.
Thank you very much, Ustaz Omar. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Wa bihi nasta'in ala umuri dunya wa din. Wassalatu wassalamu ala ashrafil anbiya'i wal mursalin Sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Subhanaka la ilma lana illa ma 'allamtana innaka antal alimul hakim. Assalamualaikum warahmatullahi wabarakatuh. Honorable Ustaz Omar, as the chairman for this workshop or talk for this afternoon. Honorable Ustaz Jamal, as the Asatizah, as the esteemed Ustaz for the Muslim Myanmar community in Singapore. Honorable Mr. Yusuf, as the chairman of the committee, the Muslim Myanmar community in Singapore, and the rest of participants, brothers and sisters of the Muslim Myanmar community in Singapore. I'm very honored and humbled to get to know all of you. And I believe this is the first time that I'm introduced to the good community, my brothers, fellow brothers and sisters in Singapore. And hopefully this will open the door for a closer interaction between myself and esteemed members of the Muslim Myanmar community in Singapore, alhamdulillah, which are considered as an important pillar of Singapore Muslim community here, even though not in large number, but alhamdulillah contributing a lot, and we are all brothers and sisters in Islam. Thank you for inviting me to share a little bit of my knowledge on an important matter concerning the distribution of estate or the distribution of inheritance after the death of any Muslims. And thank you also, Ustaz Omar, for that lengthy introduction. It's not necessary, actually. I'm quite embarrassed when you say that. Some of the info already, was already quite outdated lah. I'm not in MUIS council member anymore, right? I left about 10 years ago. I'm still in Fatwa committee in MUIS, but not as a full member, but as an associate member. I've been full member for more than 15 years, and I feel that it's enough for me. Let others have the chance, and therefore I just become an associate member. But associate member do not have that much responsibility as a full member. So that is just the difference. Anyway, let's just move on to the topic for our discussion today, which is on Faraid and estate management. So two words here, two major keywords. One is Faraid, one is estate management. Now, Faraid, as we all know, is the Islamic law of inheritance, and it only covers on how to distribute inheritance or estate after death. Whereas estate management is how we want to manage our wealth while we are still alive, in view of how it will be distributed after our death. Let me explain a little bit, right? For example, if we know, somebody knows that he has only, he's a revert, or you want to call it convert, revert, the same thing, to Islam, and he has no other siblings that are Muslims. His father's parents are non-Muslims, so he knew beforehand that if he passes on and he's still not married, then all of his property will go to Baitul Mal. Now, he wishes that some of his property, some of what he owns, to be distributed among his non-Muslim siblings and non-Muslim parents. Now, he cannot just sit back and allow Faraid to take his course, because if you allow Faraid to take his course, his parents and his siblings, they are non-Muslims, they cannot inherit from him. That is the injunction in Islam. So he has to do something, and that is what estate management is all about. How you manage your wealth so that you ensure that your wealth will be distributed according to what you wish to be distributed after your death. So two things we're going to cover today. One is understanding what is Faraid, Islamic law of inheritance, all about, and the other one is how to manage our wealth in view of how it's going to be distributed after death. And this is all in context of Singapore. I'm not talking about other countries because I'm not familiar with the laws of other countries, but I'm talking about Singapore, and we are in Singapore, and if not all of us, then majority of us are Singaporeans here. So it should be distributed according to what is the law of the land. Now, before I go to types of distribution, just a little bit of Faraid, the Islamic law of inheritance. This is something that we as Muslims must be very proud of, because there is no other religion in this world except Judaism that has a law on how to distribute our wealth after our death. So in absence of that, laws given by religion, so men have to revert to their own invention and how to distribute properties after death. Now, Judaism, it has laws and very simplistic laws, but more lopsided towards the male rather than female. For example, under the Jewish law, females cannot inherit anything. So if someone dies and he has a wife and has daughters and sons, only sons can inherit the daughters, and the wife cannot inherit anything from him. And so the son, if let's say the wife or the daughters want something from this deceased husband's properties, they have to ask from the sons. So it's not quite that fair. But if you look at Islam, right, the Islamic law of inheritance is not only fair and just because it covers both male and female, but it is also comprehensive. It has rules that needs to be studied not overnight but a long period of time, because it is quite complicated and is very mathematical. So it is intellectual, it is just, it is fair, and it covers, you know, wide spectrum of the family relationships. So that's why the Prophet ﷺ in hadith said that the Prophet ﷺ actually extol us and encourage us to study the Islamic law of inheritance, Faraid. In his hadith, he said, "Ta'allamul faraid fa innaha nisfu dinukum." He said, go and learn this Islamic law of inheritance, is Faraid, because it is half of your deen, half of your religion. So that is the importance that the Prophet ﷺ placed on Faraid. And the Prophet ﷺ in another hadith related by Abu Dawud said that one of the first knowledge that is going to be removed from Muslims and from humans in general is not the knowledge of reciting the Quran. That is going to be the last one, but the first one will be the knowledge on how to distribute estate after death. And so that the Prophet ﷺ said, there will come a time when people will argue on how to distribute, right, the inheritance, but they will not find anyone who knows how to distribute it according to the Islamic law of inheritance, because that knowledge has been removed by Allah subhanahu wa ta'ala. That is towards the end of time. So that is something that is crucial and important for us to learn and for us to to retain in our Muslim community and future generations this important aspect of the Islamic law. So let us go back a little bit when I said that when other people, other religions, Christians, for example, they do not been given by Allah, by God, right, any laws pertaining to distribution of wealth after death. So therefore, they have to, revert. They have to, go back to their own imaginative creation on how to distribute after the death of someone. So therefore, the British, they created this law. They call it the Wills Act. And it states that everyone who wants to die or who's going to die, almost all of us are going to die. He said, if you do not make any will, then you be considered as die intestate. Intestate means means without, testation means testimony, will and testimony. So you are dying without any will. And so therefore, your wealth will be distributed according to a very simplistic rule, which is what? If you have a spouse, every single cent of what you own will go to your spouse. And if you have spouse and children, they will be distributed 50-50 between spouse and children. If they have parents, then parents will come the third place, and so forth and so forth. A very simplistic distribution, because that's all what they can imagine and what they can put inside the law. And so therefore, the non-Muslims, it's very important for them to write a will, because once they write a will, they can dictate whoever they want or they wish to inherit from their wealth after their death. So they can even will away the whole of their property to their their pet dog or pet cat or another boyfriend or girlfriend, and it still be legal under the civil law. So that is under British law. So under the civil law, right, there are the two types of distribution. One is die intestate and die testate. Okay. Under the Islamic law, somehow or other, it is also being distributed like this. Distribution of wealth for people who made a will before his death, and distribution of wealth of his estate. When I talk about estate here, means the inheritance, his wealth that he left behind, right, if he made a will. Now, if you look at the civil law, right, the non-Muslims, because in Singapore, civil law covers only the non-Muslims, it does not cover Muslims. Muslims, we have another law, we call it as the Administration of Muslim Law Act. The acronym is AMLA, A-M-L-A. So Administration of Muslim Law Act was enacted in 1968, 1969. It was drafted and made into law by the late Professor Ahmad Ibrahim, who was the law minister at that time. And it covers all Muslims who reside in Singapore since 1965. So we are covered under the AMLA, but the AMLA also mentioned about people who died intestate and testate. Now, in comparison with the civil law, once a person dies, his property must be put on hold and put inside the estate account and look into whether the deceased has any, any debts that need to be cleared. Once all the debts has been cleared, only then that property, whatever left behind, be distributed to his beneficiaries according to civil law or according to his will if he made a will. But under the Islamic law, it is more refined, it is more sophisticated rather than, the civil law. So for Muslims, when any Muslims dies, his estate, whatever he left behind, cannot be distributed straight away to his inheritance, but must go through certain steps. Now, if he does not leave behind any will, there are 4 steps that need to go through before it's been distributed to his beneficiaries. Number one, right, and this is similar to the civil law, his property, whatever he left behind, must be used to clear up his financial debts to other humans. So he borrowed money, haven't returned back, or he withholds certain things belonging to other people, need to be returned back. Okay, so these are the financial debt that need to be cleared. That was, on the shoulders of the deceased person. So once that thing has been cleared, it means that his property has been, purified from everything that the deceased did not own during his death. Only after that, that second step kicks in. And that second step is burial expenses. That burial expenses in Singapore, in average is about 1,006, 1,005 to 1,007, depends on the company that the family engages. So burial expenses comes later. Now, these burial expenses must come from the deceased money. Allah Subhanahu wa Ta'ala teaches us to be independent as much as possible and to be responsible upon ourselves, even upon our death. It means that the preparation of our body, shrouding of the white cloth, washing it, burial of our body must come from what we own, and we do not need, Allah subhanahu wa ta'ala does not want us to have begging other people with hands up there and ask people to pay for our burial. No, you pay for your own burial from your own money. But that is second step. But if you have a second step, then if you want to clear the first step, it's going to take a long time. What happened to the body? The body cannot be left just like that. And so therefore, some scholars put number 2 as number 1 and number 1 as number 2. Okay. But the scholars who put burial expenses as number 2, clearance of financial debt takes precedent. For them, they said that anyone can fork out their own money first, right, for the burial. Then after that, this person can claim back the money that he spent. So being disbursed back to him from the estate of the deceased. So that will come much later, but people have to come out some money first. If there's no money, then the Baitul Mal has to come in, or the state, the government has to come in and pay for the burial, because it is very important not to let the body just like that without burying it for days and end. This is the difference of opinions among scholars, whether number 2 goes to number 1 or it remains number 2, the burial expenses. Now, once that has been cleared, then only then we go to the third step, and the third step is clearance of religious debt. Religious debt pertaining to the responsibilities, the religious responsibilities of the deceased. For example, the deceased has not been fasting for so many days, so therefore, right, the family members has to use his estate, right, to pay the fidyah for the missed number of days of Saum during Ramadan. Or the deceased has not paid his zakat yet, so take out from his estate after clearance number 1, number 2, take out from the estate and clear off the zakat. Or the deceased has not performed his hajj, so therefore take out from the deceased estate, right? Even though this is not really compulsory, because if you cannot afford to go for Hajj because you are poor, there's no compulsion for you to go there. But if you are rich and you have the ability to go, or the deceased, right? This person has the ability to go, but he did not go for whatever reason we do not know. But he has the ability, he has the money. So therefore, the family members has to clear that responsibility for him, take out his money, and then engage someone over there to perform Hajj on his behalf. We call it the Hajj Badal on the deceased behalf. So that is clearance of religious debt. And then somehow kafara, if he has to pay the penalty for breaking of vow, breaking of nazar, or breaking of any, that sort of thing. So that thing has to be taken from his estate. So number 3, anything has to do with the deceased religious responsibility that he has not discharged while he was still alive, then the family members have to clear off those religious duties or religious, we call it religious debt. Then after that, only after that, once that thing has been cleared, and if there is, a balance, whatever balance, it can be few, can be little, can be a lot, but whatever balance, only then that balance be distributed to the deceased legal beneficiaries according to the Islamic law of inheritance, Faraid. Now, if there's no balance, then nothing to be distributed to the legal beneficiaries. So the legal beneficiaries always come last. Priority is being given to the deceased himself. His body need to be built, he's buried, and then his debts to other people needs to be cleared, his religious responsibilities has to be cleared. But if, let's say, this deceased does not leave behind much money, but he's in debt with so many people, so all of his money need to be used to clear off his debts. Nothing left behind. Even with that, he still owes a lot of money to other people because he died poor. So now he has no money for number 2, his burial expenses. Then the state has to come in. In Singapore context, MUIS has to come in from the Baitul Mal, and or whatever charitable organization has to come in and bury that person's body. But there's nothing left behind to clear his religious debts. Too bad for him, and therefore his legal beneficiaries has nothing to take from his estate. So it's always, in contingent with clearance of financial debt. And that is why in Islam, it is not encouraged for us to borrow money, to be in debt. Right? We take money, we borrow money when we are in debt only when absolutely necessary. Like, for example, buying a house. We have to buy a house, right? So we are put ourselves in debt. Or we want to buy a car, so we put ourselves in debt, but we know we can clear off and it's not that expensive. So that is a little bit necessary. But if you're not in need of such cars or private transportation, you don't have to buy it because there's not something that is compulsory. So why Islam does not encourage to be in financial debt is because of what's going to happen after we die. Right? It's going to be a burden for our family members to know how much we owe other people, and then after that to pay off that debt from our own estate. So that is the main reason. Now, these are the 4 steps if the person dies without any will. If the person made a will before he died, now that will be executed before distribution to the legal beneficiaries. So after clearance of religious debt, then whatever left behind will be used to execute the will. But there are conditions of making a will in Islam. Right? I will cover that after this. So after execution of the will, then the balance will go to the legal beneficiaries. Okay, so these are the 2 ways of how Muslim estates distributed after his death. Now, we're talking about lawful beneficiaries before we talk about, wills, maybe later on, because that is part of the estate management. Talking about lawful beneficiaries or legal beneficiaries, right? Under civil law is very, very, simplistic. It's just the spouse and the children and the parents and maybe the siblings. But what if the siblings, they are step siblings, sharing the same father or sharing the same mother? Well, the civil law does not touch that. It only touches about full siblings. But in Islam, it's more sophisticated. So who are the legal beneficiaries in Islam? Right, they are, this is mentioned by Allah Subhanahu wa Ta'ala in Surah An-Nisa, and also explained further by Nabi Muhammad Sallallahu Alaihi Wasallam. So number one, of course, the spouse, if the deceased is married. It must be the legal husband or wife at the time of death. But if the wife, has been divorced, but still within the iddah period, she is still entitled from the husband's, estate, because she has not been officially separated from the husband. Divorce, when talaq is mentioned, is just halfway. It's just one foot out of the marriage house. The other foot is still inside the house. Only when the iddah has been completed, then the other feet will be out of the house, and therefore complete separation of husband and wife. So if divorce took place when the wife has been divorced, but within the iddah period, she is still entitled from the husband's estate. This is according to many scholars. Okay, now those are the spouse. Now the descendants, you can break these beneficiaries to groups of people: spouse, and then descendants. And descendants, of course, we have sons and daughter, right? And then we have grandson and granddaughter. But this grandson and granddaughter with grandchildren, they must come from the son's side, not from the daughter's side. Now, people always have thrown this question: why? Isn't grandchildren are the same from both daughters and sons? We love them together. Yes, it is the same. In terms of love, in terms of family ties, in terms of their standing in the family unit, they are the same. Grandchildren from both sides, son and daughter. But in terms of inheritance, only from the son side. Why is it so? Because number one, right? Ancestries and descendants come from the male part of the family. Number two, if let's say the grandchildren can legally inherit from their grandparents, from both their fathers and their mother's side, it's not going to be fair for other legal beneficiaries. Why? Because other beneficiaries, they can inherit once or twice only. But for these children, they can inherit up to 4 times. Grandfather, grandmother from the mother's side, grandfather, grandmother from the father's side. So they can inherit 4 times, and that is not fair. That is double the amount of time that other lawful beneficiaries can inherit. So therefore, Allah Subhanahu wa Ta'ala limit the inheritance to just from the father's side, not from the mother's side. So grandchildren can only inherit maximum 2 times, right? From the grandfather and grandmother from the father's side. From the mother's side, cannot. Okay, but they, our grandson, our granddaughter, from our daughters, they can also inherit, but not from us, but from their grandfather and grandmother from their father's side. This still can inherit, but it does not lessen any bit our love to them, right? In fact, because they are not legal beneficiaries, we can write wills and give them certain amount from our inheritance, or we can, do a hibah or give to them while we're still alive. So those are the descendants. Now, when you look at the ancestors, right, those people on top, right, they are, of course, the parents. There's the immediate ancestors to the deceased. And then we have the grandparents. Now, the grandparents, they are the grandfather, but only from the father's side, not from the mother's side. Because why? Because our lineage come from the father's side. As much as grandchildren, right, can inherit from his grandfather from his father's side, so therefore the grandfather can also inherit from the grandson or the granddaughter from the son's side, not the other part. So it is two-way and it is fair, right? You can inherit from me, I can inherit from you, you don't inherit from others. So only grandfather from the father's side. Now, what happened to the grandfather from the mother's side? They cannot inherit, right? But they are entitled to wills. But, Allah is fair. If you look at, in general society, we can see that women will outlive men. That is the basic issue, right? the the average age for women to die is around, in Singapore, is about 85 to 86 years. But for men, is between 780 to 80 to 83, around that, but it's lesser than women. So if you look around, you can see more elderly women than elderly men, because elderly men, they're invited by Allah SWT earlier than the elderly woman. So therefore, right, in reality, there are more grandmothers than grandfathers, more grandmothers than grandfathers. And so therefore, Allah protects them, and Allah says here, from the Quran and from the Hadith, that the grandmother from both sides, mother and father, can inherit from their grandchild. Whereas the grandfather, the grandfather can, from the father's side only can inherit. The grandfather from the mother's side cannot inherit. But grandmother can inherit from both sides. So if you have a grandfather, grandmother from the mother's side, right, only the grandmother can inherit from the mother's side, but his or her husband cannot inherit anything. So that is how Allah SWT protects women. Because if you look at Faraid in totality, and you really do research in it, and contemplate on how the wealth is being distributed, we can see that Faraid is actually skewed towards the female. It is always ladies first rather than the male. This is, but people always accuse Islamic law of inheritance as being patriarchal and being unfair towards women, because they did not study Faraid in depth. They just look at the surface. They just look at how it's been distributed between brothers and sisters, and after that they come up with a general ruling for all Faraid. That's totally wrong. Just like looking at Islam, that civil law, Singapore law, and you said, okay, bringing drug, the punishment is hanging to death. If you just look for that angle, then he said it's not fair. I just bring a few grams, less than 100 grams, then I'm being hanged to death, which is more precious, just a few grams of my life. But if you look at totality, you study the reason behind it, you look at how drugs destroy lives, families, and you see this is justified. So these people who accuse Faraid as being, unfair towards the females, they do not understand Faraid really well. They just, look at surface of the Faraid. So one fine example is this thing, grandmothers from both sides. So the grandmother can inherit from the granddaughter. If the granddaughter is the deceased, so she can inherit from her. But this granddaughter, if the grandmother passes on first, she cannot inherit for the grandmother. So it's a one-way street. The grandmother can take the money from the granddaughter or the grandson from the mother's side, but this grandson or granddaughter cannot inherit from the grandmother from the mother's side. It's a one-way street, whereas for the grandfather, it's a two-way street. So why? Because again, this is a very clear example that Allah SWT wants to protect all those elderly ladies, right? Whereas regardless whether you're from the father side or from the mother side, you still can get a little bit from the deceased estate, from your grandchildren's estate. So there's ancestors. Now you look at another group of beneficiaries. They are called the siblings. Now siblings, they have full siblings and half siblings. Full siblings, they share the same father and mother. Half siblings, they share only one part of the parents, whether it is the same mother or just the same father. So if they share the same mother, different fathers, they are they are maternal siblings. If they share the same father, different mother, I mean their father marries two or married twice, so therefore they're called paternal siblings. Now in terms of inheritance, okay, the full siblings they are given priority of inheritance. If they are around, the half siblings from the paternal side will be blocked. They cannot inherit, blocked by the existence of the full siblings. Okay, but the maternal siblings, can still inherit, even though there are full siblings there. So if you have, a huge family, a happy family, we have full siblings, we have paternal siblings, we have maternal siblings. All right. and then after that, one of them dies. So full siblings, of course, we inherit from the deceased because they are, you know, full brother, my full sister. But the paternal siblings cannot inherit. Why? Because, you know, you just share the same father, not the same mother, even though we share the same lineage, right? But you cannot inherit because I block you. I'm closer to this deceased because we share the same father and mother. However, the full siblings who share the same father and mother with the deceased cannot block the maternal siblings from inheritance. It means that the one who share the same mother, different father, even though different lineage, they can still inherit. Whereas the one who share the same lineage but different mother cannot inherit when full siblings are around. Why? Why can't the full siblings just block both half siblings, paternal and maternal? The reason being, you look at, you know, the social context. You look at what is, you know, common among family members. The normal case is usually full siblings and paternal siblings, or siblings that share the same father, different mother, you know, share the same father but different mother, they are not always on good terms. They are not close. Why they're not close? Because they are being raised by two women, two families. The one that unite these two families is just one man. That is the father of these two siblings. So they live in different household, and then another one live in different household. Whereas a maternal siblings who share the same mother, different father, of course, right? The mother cannot have two husbands at the same time. So usually the case that the mother has a child from a different husband and divorced or died and then married another and have children. So these two children, they are maternal siblings. They share the same mother but different father. Okay, lineage is different, but they are being raised by the same woman, the same mother. And so therefore, the feelings are closer. They are as if they are like full siblings, not paternal siblings, not maternal siblings. They are like full siblings, even though they have different lineage. They have different father. But because the love is there, united by one person, and that is the mother who raised all of them together. The power of love from the mother, right, will overcome everything. So therefore, right, full siblings cannot block maternal siblings from inheritance because they are just like full siblings, but full siblings can block paternal siblings, right? Because paternal siblings, they are of, you know, lower degree rather than full siblings. Full siblings are closer to the deceased. Paternal siblings are not that close to the deceased. So that is how, you know, Faraid Islamic of inheritance. It's not just, you know, you take this, you take that. There are reasons behind it, and those reasons are basically, you know, social context between family members. So these are the siblings. Now you look at the last group of beneficiaries. This group, we call it others lah, because we lump everyone else in this last group, and they are, you know, the male family members. They are quite distant from the deceased. It includes paternal uncle, paternal male cousins, and paternal nephews. They are far. So uncles, cousins, nephews, right? We are still connected to them, but we are not as close to them as we are to our, you know, our own siblings, to our own grandparents or own parents, or even our you know, our spouse. So we know they are there, but yeah, sometimes we just meet once a year, twice a year, sometimes not at all. Sometimes we know the name, but we never meet them, right? Last time we met a decade ago, but they are still family members, so they can inherit. But they can only inherit when the siblings are not there. If the siblings are there, whether full, half siblings, if they are around, then all these others group of beneficiaries, paternal uncle, male cousin, nephews, they cannot inherit from the deceased estate. So they are the fringe, what do you call it, beneficiaries. So these are the, you know, lawful beneficiaries or legal beneficiaries under Faraid. Now let's move on to the provisions for rightful beneficiaries. All these beneficiaries, they must first and foremost be Muslim. If they are not Muslim, they cannot inherit. right? Because the Prophet SAW said in a hadith, "La yarithul muslimul kafira walal kafirul muslima." It means that the non-believers cannot inherit from the believers, and the believers cannot inherit from the non-believers. So it's vice versa. So they must be within the same religion. And number two, right, the beneficiaries are not implicated in any suspected murder or death of the deceased. If you are implicated, you cannot inherit from the deceased estate, whether it be murder or manslaughter, right? Anything that you have to do, I mean, you are connected to the deceased death, that is the reason for you to be blocked from inheriting the deceased estate. Okay. So these are the two provisions. Questions being asked always this question, common question, why non-Muslims cannot inherit from the Muslims, even though they are their parents, they are closest to them, but they are non-Muslims. Why can't they inherit? Now the reason is this, right? We do not know what the non-Muslims will do from the Muslims' money or Muslim estate. They might take it and donate it to the temple, to the church, to the synagogue, and use it for the worship of, things that are, of shirk. Or they can use it for sinful purposes. There's no guarantee that they will use whatever been given to them for, something that is good or bring benefit to others. So because of that, we cannot ensure that they will not, under Islamic law, abuse the money given to them. So to avoid that, this money from deceased can only be given to the Muslims. Now, what if, right, this convert, right, a very rich convert, then dies, leave behind a lot of money, but has no legal beneficiaries because all of them are non-Muslims. But the parents are poor. So are we going to deprive the parents from their child, the deceased child, just because of religion, right? Make that the parents still poor, whereas the parents are the ones who raise this deceased from young, give him food, education, and so forth. And we deprive these parents of their child's estate, their child's wealth. That is not fair, right? Well, there are ways to give the money to the parents, and that is through Baitul Mal. And that is the provision is like this, right? The deceased estate will be given to Baitul Mal, administered by Muiz, and then the parents will come in and request the Baitul Mal to give the money to them. And Baitul Mal, after checking, is case by case basis, and so therefore it's always the case that Baitul Mal will release the deceased estate entrusted to Baitul Mal, given to Baitul Mal, and release it to the deceased non-Muslim parents. Not 100%, but close to 100%. Might be 95%, 90%, because the balance 10% will be used by Muiz to, for charitable purposes, so that the Muslim deceased, will get some rewards in his afterlife. But not 100%. This is how Singapore works. I cannot talk about other countries, but in Singapore, this is the system. So the converts must always remind the parents, if you don't get anything from me, if I die a sudden death, and my money goes to Baitul Mal, Muiz, just go to Muiz, right? Show proof that you are my parents, and request that the money be released to you, my money be released to you, and Muiz will do the rest, and the money will be released to you. It will not be held by Muiz, but not 100%, of course. Okay, so these are the provisions for rightful beneficiaries. Now, like I said, the Islamic law of inheritance is mathematical in nature, right? It is sophisticated, not like civil law, not like the Jewish law. So because of the sophisticated nature of the Islamic law of inheritance, you can see that those companions of the Prophet ﷺ, some of them were genius, mathematically genius. They can just, calculate fast on their feet while giving sermon. There's this one example where, Sayyidina Umar bin Khattab radiallahu anh, he was giving sermon, and then came a lady, right? And then suddenly she shouted a question to, not Sayyidina Umar, Sayyidina Ali, sorry, Sayyidina Ali. She shouted a question to Sayyidina Ali and asked a question on inheritance. this person, and how much will I earn? How many percent will I earn? Sayyidina Ali, without pausing for long, he just gave the answer straight away. Your portion is, after he did all the calculations in his mind, is how many shares out of how many shares. And this one, how many shares, he can just solve the issue, right? Just there and then. Mathematically genius, all these companions. Allah SWT selected them. There are reasons why Allah selected them to be the companions of the Prophet SAW and not us. We are far removed, our iman is far removed from their iman. So let's go back to these shares in Islamic law, right? They can be based on 2, based on 3. It is sophisticated but simple in its essence. Based on 2, based on 3. So if it's based on 2, we start with half. That is the largest share based on 2. Then after that, half of half is 1/4. Half of 1/4 is 1/8, and that's it. 1/8 is the lowest fraction being given to any beneficiaries. Now, if it's based on 3, then 2/3 is the largest fraction based on number 3. Half of 2/3 is 1/3. Half of 1/3 is 1/6. So it's simple in nature, yet if you want to do calculations, it's going to be a little bit complicated, because let's say, for example, you have 1/8 and you have 1/6. How you want to distribute that? You have to find, if you learn mathematics, you have to find the lowest common multiple of 8 and 6, and that is 24, because 24 is divisible by 8 and divisible by 6. Anything higher than 24 can also be divisible by 8 and 6, but is not lowest anymore. You want to have lowest common multiple of both numbers. So that is how we do it lah. And fraction is more accurate than decimal. Faraid does not use decimal, he uses fraction. Why? Because decimal is human invention and is for convenient, we can figure it out, but it is not accurate because it has a lot of decimal numbers which you cannot actually distribute it. How you want to determine the cost of this thing is $3.563. $3.5634. How you going to 64 cents over there? So it is impossible, but you convert it to fraction, you have a whole number, a very beautiful number. Just take one very good example. I know this is a little bit, for those who studied maths a long time ago, but in a circle, there is something that's called pi. And pi is a number that's important to calculate the radius and the circumference and also the area of the circle. And pi is in fraction form is 22/7. But if you have to convert it to decimal, it's going to be endless number of numbers, right? Endless numbers after the decimal point, endless. So people, they have this formula that can generate until the 1,000 places, decimal places of pi. Why? Because it's not accurate, right? It is based on formulas. So that is why in Islam, right, we use fractions, and fractions is the original mathematics for humans. So the scholars, the Prophet ﷺ and his companions, they use fractions when they distribute the shares of the beneficiaries. I'm not here to share to share with you how is the calculation is being done. That needs to a long workshop on how it's going to be calculated, but just for our sake of understanding that these are the fractions used in Faraid. Now we have covered already the first part, which is on the Faraid. Moving on, we're going to cover the second part, which is on the estate management, how we want to manage our wealth so that we know our wealth will go to who after we pass on. And we can actually manage so that this money goes to this person more than that person, not overriding the Faraid, right? But because, Faraid is a general rule, whereas each family have its own specific peculiarities. Relationship between humans are not fixed. It's dynamic. It's very fluid. It can change overnight. Right? So therefore, you can't use a general rule that fits in all situations. So Faraid exists when beneficiaries argue among themselves on how to distribute the estate of the deceased. If they do not argue among themselves, and if they can distribute the estate, right, among themselves, in harmony without quarreling, and they say this, we distribute it equally, then you can just distribute like that. You have to follow Faraid. Faraid is the last resort if the beneficiaries cannot distribute the estate according to their own agreements, mutual agreements. So once they cannot have that mutual agreements, therefore Faraid kicks in, and when Faraid kicks in, nobody can argue, because that is the rule from Allah subhanahu wa ta'ala. So contrary to common belief, right, it's a misconception actually that Faraid must be implemented immediately after death, and there's no other means and recourse to distribute the deceased estate. No, that is a common misconception, right? The first priority and the preferred method of distribution is through mutual understanding and agreement among the legal beneficiaries, among the siblings, among the children and spouse. How you want to distribute it? And everyone agrees, okay, we're going to just take half, 50%, 50% donate on the deceased name, or we distribute equally among ourselves. That is the preferred method. You don't have to revert back to Faraid. But if one of them or some of them do not agree with that kind of distribution, equal distribution or whatever, so then, right, we go back to Faraid, and therefore these persons who, right, do not agree with the distribution equally or whatever mutual agreement among other siblings, their shares have to be given to them according to the Faraid law. So Faraid is the last resort if there is no mutual agreement between the beneficiaries on how to distribute the estate. Okay, so estate management is not overriding Faraid. Actually, it is actually distributing somebody's wealth, or the person's wealth according to the peculiarities or the dynamics, the unique dynamics of his family relationship. Okay, whether there are estranged siblings or what, or a lot of contextual things that change from one family to another. So estate management is important, and the first and foremost estate management that should be done by us is will, making a will. But will only kicks in after death. So as long as, if we make a will, as long as we are alive, right, that money belongs to us. Only after we pass us on, then our money will be distributed according to the will, or wasiyah in Islam. But will has its own, conditions that to be fulfilled. I will cover after this, short while after this. The second instrument for distribution, estate management, is by gift, and this happens before death. You cannot give after death. If you want to give after death, you have to put it inside the will. If you want to give before death, then it's considered as gift. It's hibah or hadiyah or sadaqah, or whatever you call it. It is, basically just, a transfer of ownership of one thing from the original owner to the second owner. That is the gift. Okay, and it kicks in before death. But there are, of course, conditions for making gift. Now, let's start with the will first, right? To make a will in Islam, there are two conditions, very simple conditions. Number one, right, the one who makes the will cannot will away more than 1/3 of his total estate. Now, he does not know how much is the total estate because he's still living, right? It's only after his death or during his death, then the beneficiaries will know, the family members will know how much the deceased owns. So we can go by fraction. So it can be 1/3, it can be 1/6, it can be 1/7, it can be 1/5, anything that is below 1/3. And 1/3 is, if you change to fraction, if you change to decimal, is 33.33333%. Nonsense lah. So anyway, we can take a ballpark figure of not exceeding 33%, or a more simpler number will be 30%. do not make a will that exceeds more than 30%. Because the Prophet SAW, right, forbade from making a will of more than 1/3. And 1/3 is already considered as a lot. وَالثُّلُثُ كَثِيرٌ, the Prophet SAW said. And 1/3 is already a lot. Okay. So in other words, right, under Islamic law, somebody cannot will away all of his wealth to anyone he wish. There must be 2/3, at least 2/3 of his property or what he owns to be distributed and given to his rightful beneficiaries. So only 1/3 or lesser than 1/3. Okay, but under the civil law, because there's this thing called Wills Act, so therefore whoever non-Muslims who make a will, right, the will will kick in first, and so therefore distribution to the rightful beneficiaries will not happen. If the will is for other parties, not the rightful beneficiaries, then too bad for the rightful beneficiaries. They cannot get anything. So under the civil law, you can will away, the non-Muslim can will away even to 100% of his estate to anyone that he wish, even if it covers his lawful beneficiaries. So there are cases, you know, in Hong Kong, for example, right, this wealthy lady, right, will away 100% of her estate, millions and millions of dollars, to her Feng Shui master. Because the Feng Shui master somehow rather said that, no, you must give it to me. If not, your afterlife will be horrible, horrible, horrible. Punished towards end. So you give me money, you'll be safe afterlife. Okay, so write the will. And then challenge in court. Because the children come in and said, no, this Feng Shui master is, you know, he's a fraud. Right? He just wants to take my grandmother or my mother's money away. So therefore in court. So I don't know what's the outcome of it, but that's what happened. You know, but if let's say in Islam only 1/3 you can will away, it means that there'll be no quarrel in court because 2/3 will still go to the rightful beneficiaries. And that's number one. Number two, right? The condition number two is that the will cannot be given to your lawful beneficiaries. So if you know that no, your husband, your wife will get it, your children will get it, your parents will get it. So you cannot add on to their shares by making a will and say, I'm willing away $20,000 to my spouse, my husband. Your husband already get the money after your death, right? The fraction is already being allotted by Islam, by Quran to him. He's going to get half or quarter of what you have when you pass us on. So you don't add to that. Because if you add to that, then other legal beneficiaries will accuse the one who get more than his share through will that you are actually, you know, you trick this deceased so that the deceased will give you money, and then the quarrel will set in. So to avoid all these things, Islam said you cannot will away to your rightful beneficiaries, only to those who will not get from the 2/3 balance of your estate after you make that will. Right? So those 2/3 who are not the lawful beneficiaries, they include your grandchildren from your daughter's side, right? Or your siblings. If let's say you have sons, and once you have a son, the siblings will not get anything. So you will away something to your siblings. Your cousins will be blocked by your siblings, but you love your cousins so much, so you make a will for that cousin. But again, everything must be within 1/3. Cannot be more than that, so that there will be no quarrel among the family members. So Islam is very beautiful. It is a clear proof that this Faraid law, right, does not come from humans, because humans cannot think this complicated manner. If you accuse those Arabs who living during the time of the Prophet ﷺ of coming up with this sophisticated rule, right, then you're giving too much credence to them, or you much credit to them, because they are, you know, they are just Arabs. Most of them, majority of them, are not educated, but you come up with such, you know, rulings that even all those esteemed judges under the Commonwealth law, they cannot even come up with such, you know, beautiful rulings that cover all aspects of family law. It's only clear that this comes from God, who created humans and knows, right, the dynamic relationship between family members of his servants. So these other two conditions need to be remembered when making wills. Now, making will usually is to, making sadaqah jariyah, so that we can benefit from our wealth after we die. We do not just, want our wealth to be enjoyed by those people alive after us. What about us? We are the one who, shed sweat and tears, right? Collecting all this money, and suddenly if I goes on, I kick the bucket, you enjoy my wealth, you buy Ferrari, Porsche, big house, whereas I'm inside this very tiny place with all the worms and dark places. I want to enjoy my wealth also after I die. By way of what? By way of sadaqah jariyah. Make a will. Not more than 1/3. And this will is a sadaqah for all those, charitable organizations, whether Islamic or non-Islamic, mosque or madrasa, whatever, so that you will reap that rewards after we passes on. So that is why making a will is encouraged in Islam. Now, what is these things, right? If let's say you want to make a will, right? When you want to make a will, it is when you want to give 1/3 of your property to non-rightful beneficiaries, and you want that 1/3 to be transferred after your death. But if you want more than 1/3, right, to be given to whether your rightful beneficiaries or your non-rightful beneficiaries, or you want to make it happen during your lifetime, then will is not the instrument. You have to use the gift instrument. So during the gift instrument, this is, in legal terms, it's called inter vivos gift, means within two living person. So the giver and the receiver, and it happens when both are alive. So when this happens, you are not limited to 1/3 rule. You can give even 100% of what you own. Just like, Sayyidina Abu Bakar Siddiq radiallahu anhu, when he made the sadaqah, when the Prophet SAW asked Muslims to make sadaqah for the cause of jihad fi sabilillah, and he gave to the Prophet SAW for the cause of jihad everything that he owns, every single cent, every single wealth. The Prophet knew, and the Prophet asked him, what you left behind, Abu Bakr, for your family members? And he said, I leave behind Allah and the Prophet and his Prophet, and that is more than sufficient for them and for me. That's how his iman is. His iman was so strong. He doesn't care about this food. It's enough, Allah and his Prophet for me. All these things can take, no problem. Of course, Allah subhanahu wa ta'ala, compensate back to him his wealth, and he was among one of the wealthy, companions of the Prophet sallallahu alaihi wasallam. So you can give away even 100% of what we have, right, by way of gift and way of sadaqah. But there are conditions. The condition is that the giver must indicate clearly the recipient, who you want to give, and the amount to give without any coercion. It must be of the person's own free will, and he must do it while he was still, have the capacity to think. And then the receiver must sign the acceptance form. I already received the thing. So once he received, then that thing has been transferred, and therefore, right, it is non-revocable, irrevocable. The giver cannot take back the thing that he gave to the recipient. Okay, that is gift, so it can be done. Now, another thing that you can hear often is nuzriya. Nuzriya is a vow. It's from the word nazar, and this is the promise that one makes to Allah subhanahu wa ta'ala to give something by way of charity to someone else, to a charitable organization or whatever. Right? So it is a promise that the person makes to give, to make that sadaqah. But not now. If I want to give now, I give by way of gift. I say, don't just give away, then there's it finished. But I don't want to give now. I still want to use the money, but I want to give as close as possible to the time of my death. But we do not know when we're going to die, how we're going to die. So therefore, we make that promise to Allah. Whenever I die, 1 hour before my sudden death, or 3 days before the terminal illness that caused my death, I make the vow that on that moment, 3 days before terminal illness or 1 hour before sudden death, my property will be transferred to so and so. So when the person who makes the nazar passes on, And people look at the document, the Nazar document, and they knew that the property mentioned in that Nazar document does not constitute part of the deceased estate, because it's already been given to someone else while the deceased was still alive. So when the deceased passes on, close his eyes, right, those things did not belong to him, but it belongs to the other person by way of Nazar. But once who makes the Nazar must, judge by himself and see that there's no injustice done to the legal beneficiaries. That is, his responsibility, because ultimately he will be questioned by Allah subhanahu wa ta'ala later on whether he has been he's done injustice to his legal beneficiaries or not. So we cannot judge. We cannot say, you don't make Nazar, you're doing injustice to us. We do not know the family dynamics of that person. So we always remind that if you want to do this, make sure that no injustice being done, because you're being questioned by Allah subhanahu wa ta'ala in the hereafter. So whether justice done or not, it's none of our business. Now, number 3, right, the recipients of that nuzuria, the gift, need not be informed, because the gift is not straight away being given to him or to that organization. It is only being given to that organization, right, after the deceased death, because the deceased already made the nazar and should be transferred before his death, but the proper transfer will take place after death. So they need to inform the recipients of the nazar. That's one. Number 2, the reason is that nazar, a vow, once made, if you can't fulfill it, you can change it, even though it's not encouraged lah. Right? So you make a nazar, somebody make a nazar to give his saving banks to his wife, for example, right? Then suddenly Allah SWT decreed that they go through divorce and both go separate ways, and so the husband wants to change the nazar, because this person that I want to give no longer my wife, and I have a new person, new wife, so I want to give to my new wife instead of this ex-wife, but already make that vow to the ex-wife. So you break that vow, you pay that penalty, and that penalty is called kafara. Once you pay that penalty, and it is feeding 10 poor and needy people, right? Feeding them for 1 full meal a day. So take it by $25 if you want to eat 1 full meal a day, right? Or 3 meals a day, and you multiply by 10, so it's easily $250 around that, right? $250 of penalty you need to pay, right, to break the nazar. Once you pay that nazar, means you have done the kafara. That nazar is considered as invalid, and therefore you can make a new nazar. So that is the reason, one of the reasons why we don't inform the recipients of the nuzuria, because we can retain the rights to change that nazar anytime in the future if circumstances change. Now, all these are fatwas after this, right? Joint tenancy. If let's say you are living in a HDB flat and you bought that house, that flat, under joint tenancy agreement, so between husband and wife, or usually husband and wife, right? Under the 2019 fatwa issued by MUIS, right? I say that the surviving joint tenant, we have 100% absolute ownership of the property without the need for a transfer of ownership from the deceased to the surviving joint tenant. So it means that, right, if it's joint tenant, husband and wife, husband passes on, the house will belongs to the wife fully. If the wife passes on, then the husband will own the house fully. That is the fatwa issued by MUIS in 2019 with regards only to joint tenancy between husband and wife. But if it's a joint tenancy between siblings, no, cannot. Why? Because siblings, they might, every one of them put in money. So the deceased might put in money. So if the deceased passes on, then the money that he has contributed to the house, payment to the house, must be distributed to his rightful beneficiaries. So the surviving partner cannot take just the house fully. He does not own the house fully. He just pump in certain amount of money. So therefore, this 2019 fatwa is more for for husband and wife rather than between other types of joint tenants. Now, for CPF is simpler. 2010 fatwa issued by MUI said that no nomination that we have done is considered as hibah. That's basically it is. So if let's say I make a nomination of my CPF to my wife, to my children, right? So therefore, when I passes on, right, the CPF board will give the money to the public trustee. Public trustee will immediately execute that nomination and give checks to the one who are being nominated inside the nomination form, and the one who received the check can be considered as, you know, it's your money because the deceased already has the intention to give the money to you, hibah to you. You don't have to, you know, distribute back to the rightful beneficiaries. So CPF is more straightforward. And then we have insurance. Insurance is the same as CPF. It is more life insurance rather than other types of insurance, endowment fund. No, we're not covering that. This is life insurance. Because under life insurance, there is so-called as nomination. If the person dies, the policy owner, policy holder dies, then the payout will be given to who? Right? The insurance company wants to know. So you make that nomination. So this nomination is considered as hibah, right? As a gift, just like a CPF nomination. So the one who has been given the payout from the insurance company, that person can enjoy the money to whatever he wants, right? Because that is 100% his or hers. Now, bank account, right? For single account, is 100% Faraid. If somebody has a single account, so whatever he has in that bank account is 100% goes to rightful beneficiaries. But if it's joint alternate account, which means that 2%, right, in that account, one can put in any much that the person want, and one can withdraw it much that the person want, because it's joint alternate. So therefore, if one passes on, right, the only 50% of the money in the bank will goes to the deceased estate. The rest 50% will goes back or belongs to the surviving second name, or the second account holder. So this is under Islamic law, but under civil law, right, to withdraw the money from the bank, if you want to do it by legal way, it's going to take a long time, because you have to lodge in, you know, to make a letter of inheritance from lawyers, and it's not cheap. Letter of inheritance can easily goes to $3,000, $4,000, or as cheap as $1,000. Depends on the number of estate concerned. So the lawyer say, oh, this deceased owns a lot of property, so I better tekan, I better, you know, press this person for money, and he might charge, you know, $4,000, $5,000. But if the deceased has only of not much property, not much money, so the lawyer will have, you know, sympathy and say, okay, just $1,000 is enough. But the thing is that the process takes a long time, and all this time the money is stuck frozen inside the bank account. Even after everything has been cleared, go to the bank still will freeze the account for at least 6 to 9 months before allowing the beneficiaries to withdraw the money. Why? Because this 6 to 9 months is called as the waiting period if, let's say, there are claims to the deceased estate because of the deceased debts that's not been paid yet. So it's troublesome. So what usually people do is that people take the deceased ATM and withdraw every day $2,000. Provided that that person knows the PIN number. If the person does not know PIN number, then there's no use, you know, withdrawing money from the ATM card. Or, right, if you know the internet, you know, internet banking, this is for single account, internet banking of the deceased, then you just, you know, transfer the money from the deceased account to another account and then withdraw it and then distribute according to Faraid, because this is a single account. But never ever, right, inform the bank, because once you inform the bank, then police will come into the picture, because you are withdrawing the money of a deceased person. So you might be stealing the money, right? Under the law, you are stealing. You're going to say, no, I'm not stealing, I'm distributing it back to the legal beneficiaries. Who cares your intention? The act itself shows that you are stealing, and that's it. So if people want to resort to this sort of method, they have to keep it quiet, right? The bank does not want to know, right? And therefore, you don't tell the bank. Because if you tell the bank are forced to know, then of course legal actions will be taken. Now, but if you join alternate, it's easier. The surviving account holder can close the account, take out all the money, and 50% distributed to Faraid, and then 50% that surviving account holder will take it and then, you know, enjoy it. Okay, so this is for bank account. So I think that's about it. Thank you very much. Wow, exactly 6:30. Alhamdulillah. So thank you very much. I pass it over to Ustaz Omar.
MashaAllah. Thank you so much, Mr. Dr. Firdaus Yahya. So such a wonderful sharing with your incredible knowledge gifted by Allah and your experience in this field. You can make the Faraid inheritance topic in such 1 hour short and sweet, and then it's very clear for us. So I remember in Islamic University, they put this subject for the 4th semesters, 2 years, syllable. But mashallah, so today you enlighten us, within this short timing. So thank you so much, Jazakumullah khairan. So we have a few questions in the chat box before we take the questions from the floor. So I would like to mention to you, I think you can also read from the chat box of starting from the Mr. Zafar Ba'u. So for this Q&A session, I would like to hand over to Ustaz Jamal to be the moderating the Q&A session. So Ustaz Jamal, could you please start from the Mr. Zafar Ba'u question in the chat box? Sir, can you see it in the chat box? Please unmute, sir. Ustaz Jamal, mic lip pun
okay, chat box. I do not know where to go.
Oh, okay, sure. I will read it out.
You read it out, please.
Yes, sure, sir. So, Ustaz Firdaus, sorry.
Okay.
Yeah.
I can see the question here.
Yeah, right. Number 1, can the son without any children who has passed away? Yeah, from the question, we can answer them.
The answer is no, right? Because beneficiaries must be alive.
Oh, I see.
When the deceased passes on. Only then the money can be transferred to that person.
This is Singapore law.
Huh?
This is Singapore law, right?
No, it's not Singapore law. This is
Sharia. According to Sharia, yes.
Law. The Sharia law.
Everywhere.
The beneficiaries must be alive even for 1 second when the death happens. Only then the beneficiaries can inherit. If he passes on before, he cannot inherit. Because he's not in this world anymore to inherit anything.
Oh, I see.
Okay?
Unless he leave the will.
Unless he leave, no, even he leave a will to a person who has passes on, that person cannot get anything. Legally under civil law, both under civil law and Sharia law, both cannot inherit anything because you are not already in this world. So you can only will away to recipients who will be alive when you passes on.
Or the one who is going to be alive, yes.
Yeah.
Assalamualaikum. Assalamualaikum. I am the questionnaire. Yeah, sorry. The question I ask is the person, okay, the son who passed away before his father and mother, but his actually he has no children and his wife also passed away already. So I assume that they are not. He is not under beneficiary. Am I right?
Somebody who has any children and passed away, but he has no other. His children already passed away before him.
Oh, I see.
His wife already passed away before him, so they are no longer in this world to inherit from him.
Oh, I see.
Okay, so no inheritance.
I got it. Yeah.
Okay.
Yeah. Thank you very much. Thank you very much. Assalamualaikum.
Waalaikumsalam.
Assalamualaikum, Ustaz.
Sorry, Mr. Tinku. How about we answer all the questions in the chat box, we clear it, and later on we will come back to you. Thank you.
Okay, thank you, Ustaz Omar. So there's a question here. Ustaz Jamal, can I just proceed?
Yeah, please go ahead.
So this is from a person, I do not know how to pronounce this name, maybe.
Is it Yadana?
Yadana Mom?
So yes, there's a question is from Yadana Mom. She is asking, could you please give us your PPT, the PowerPoint slides?
Yeah, sure. We can, inshallah. I can pass it through Ustaz Omar later on.
Yeah, I will send to all the members. Thank you, Jazakumullah khair. So we go to the next question is from Brother Zimbo. Salam Ustaz. Ustaz here, please.
Okay, so as per Singapore law, do Singapore Muslims can consider to look into estate management as first resort and then second as Faraid? You know, estate management is not covered by Singapore AMLA law. you can do it, right? Because it's a gift. It's covered under civil law also, because once you make a gift, then there's it. You make a will, then there's it also. So once you make that thing, then that thing will kick in first, then Faraid will come second. Okay.
So is it clear, Idana? Simple?
Yeah. Thank you. Yeah, clear, sir.
Okay.
Thank you.
Okay, thank you. Next.
Next, the questioner is Mr. Hanton. Salam Ustad, how to make it and any charges? Sorry, could you please?
What charges is it?
Yeah, switch on your. Yes.
I would like to know any procedure to legally do it. This one here.
Yeah, to make a will, right? You can engage anyone who knows how to make a will. You don't have to engage a lawyer.
Or not Ustaz, you are doing one.
I can also do. do. Okay. It differs lah. I mean, lawyers will usually charge thousands of dollars because they are lawyers. But if it's a simple will, then anyone can do it, right? Anyone who has the knowledge to read, or companies that do up wills, they will do it. And charges vary from one company to another. So that's the answer.
So if I want to do the
will,
all this together, Ustaz, can you arrange?
I can help. Okay, because I'm doing it under the Sharia consultancy company. So the charges will be the Sharia consultancy company, and it is the lowest in town now. I'm not advertising, right?
Can you please let us have an address?
The document is just per document. The first document is just $370. Just 370. If somebody needs a second document, then the second document is another $220. So
what are those first document?
What do you mean? Sorry?
What are the first document and second document?
Yeah, document means that they say a husband and wife wants to make it.
Oh, I see. I see.
One document for husband, one document for wife. So you just combine that together.
How about we got 2 kids? That means we have to make the 4 documents, is it?
Yeah. So
no
documents. If the kids wants to make, then of course the kid has to make another document. So it all depends on circumstances lah.
Okay. So this will, hiba, deeds, all are separate or
yes, separate.
One or separate?
No, it must be separated because it's not going to be legal under the civil law. It's going to be rejected by court.
Oh, so okay. Ustaz, can you give us your address? We would like to
the website. Now that Ustaz has given you the website, right?
Yeah, whoever wants it can ask Ustaz Omar lah.
Okay.
Ustaz Omar, can you please share the
website?
Yeah, share the website, please.
Dr. Firdaus?
I type here. Okay, very simple. It is I type here shariahconsultancy.com.
Yes, please.
Is it shariahconsultancy.com?
Okay, thank you very much.
So that's about it.
So for information, you can contact, please. Thank you.
Yeah. So, okay, I think check box is quite clear. And then now, Kutingu, would you like to proceed your question, please?
Yes, of course. Hello, Assalamualaikum, Ustaz.
Assalamualaikum.
Yeah, I'm just wondering, since you say, according to your presentation, just now your explanation, point number 2, you say, Nadrila. The one about the vow.
Hiba.
Hiba can override the FIRA?
Yep. Yes.
It's based on, can we know what is the background?
Okay.
Why can override the Sharia law by owner, individual owns their willingness?
All right. I say it overrides because, hiba basically takes place while you're still alive. I give this pen to you, now the pen belongs to you. So now that pen does not belong to me. So if I die, that pen does not come under my estate. So it is not among the Faraid to be distributed. You get what I mean? So Faraid only kicks in after death. Hiba kicks in before death. So while the person is still alive, Hiba already takes place, right? So Faraid does not happen yet. Faraid only happens after the person's death. So it is much later. So we're not talking about overriding Faraid. We're not talking about that. Just saying that Hiba once happens, it removes some of the deceased estate from distribution according to Faraid. Why it removes? Because now it belongs to someone else. Does not belong to the deceased. It's already been transferred before death. Just like, for example, I give a simple example, right? I have a land, right? If I don't do anything to the land, if I passes on, then the land will be distributed to my beneficiaries according to Faraid, right? That is correct. Now, if let's say before my death, right, while I'm still alive, I give my land to so and so. So transfer already to so and so. Then I die. Will that land be distributed to my beneficiaries according to Faraid or not? No. Why? Because it does not belong to me. It belongs to that person, already give to that person. So that is basically hibah, right? A gift given, right, kicks in before death, and so Faraid does not have anything to do with the thing that's already been given before death.
So if it's like this, how about the inheritance? After they know about, they didn't aware this thing, their father or their successor, beneficiary.
Yeah.
He did it already, but they didn't aware. They don't have acknowledged. So all of a sudden they are find out and they got into supply.
Yeah. So that is why, right, when people wants to give, they have to make a document. If there's no document, there's no proof that the hibah or the gift takes place. Okay, have a proper document witnessed by 2 male Muslims. Then after that, this document shown to the beneficiary say, look, the deceased is already transferred before his death. So this piece of land already belongs to that person, does not belong to all of you anymore, because that piece of land, right, does not belong to the deceased when he died. So it's not being transferred to the reformations, but you must have the document. No document, no claim. Okay.
Doctor, here let me say one word. Here the property has to be only not more than 1/3, right? As you mentioned.
That is with the will.
That is with the will.
Hibah can be more than 1/3.
So hibah can be he is free to give as much as he wants.
Yes. So free as much as he wants to whomever he wants.
I see. So that means it may be considered as injustice to the Faraid holders?
Yes, it can be. It can be also. That's why I said here, who wants to make a will, right? Point. Where is it? This one. Point number 2. Must avoid any form of injustice to legal beneficiaries.
Yes, that is what you have also mentioned. And Rasulullah said, you know that the person he visited in the sick bed, he suggested whether he should donate all the money. He said, no, you cannot donate all the money. He said, maybe I can give the half. Is it too much? Okay, then he came back again, asked, it is 1/3, al-thuluth? He said, al-thuluthu kathir. So this hadith. So that means hiba maybe not valid, I suppose?
No, that scholars agree that hadith concerns will, not hiba.
But actually, I say, because the Sahabi is asking Rasulullah sallallahu alaihi wasallam while visiting him, he was asking whether he should donate as much as he can.
Yeah.
So he cannot donate as much as he can, right?
Yes.
But here also the person who is going to give the hiba also while alive. So while alive, how can he give as a hiba more than 1/3? So this principle is not clashing with the principle of not donating more than 1/3?
Okay, let me clarify here. The hadith, why the scholar said that 1/3 that 1/3 rule applies only to wills, not hibah, because number one, the Prophet ﷺ said it is better for you to leave
For
your
your
beneficiaries sufficient with money rather than leaving them poor
in
and
need.
asking people for money. So
Correct.
that is indicator that that Sahabi wants to make a will. If he wants to make a gift, right, that gift is not valid. It's not valid. Why? Because he is on the deathbed. He considers on deathbed. So that is reason number two why scholars said that that hadith refers to a will, not a gift.
I see.
If it's the gift, the Prophet ﷺ, no, you cannot give anything, not even 1/3, because you are dying.
I see.
So that is the reason. Now, why gift is not limited to 1/3 because of that hadith? Reason number three is that if, let's say, we are still healthy, right, and then we want to give everything that we want to whomever we want, 100% more than 1 or 50% whatever we want, there is nothing in Islamic Sharia that stop us from doing it. Just like Sayyidina Abu Bakr Siddiq, give everything that he gets. And the Prophet ﷺ never stopped him, right? So we can donate 50% of all our property, 70% of our property is still valid. We are not limited by 1/3 of what we own to donate or to give.
So maybe the beneficiaries can object.
The beneficiaries cannot object because the beneficiaries do not own that thing. How can you object on distribution of a property which does not belong to you?
Is it allowed to make a hiba without the knowledge of the beneficiaries?
Yes, it is legal under Islamic law to make that hiba without informing the beneficiaries, because this is my property and I can do whatever I want while I'm still alive. Even if I want to donate 70% of it to whomever I want, is up to me, right? You do not have any right to object because you do not own my property yet. It's only after I die that you are going to own it.
But
so
okay,
you
it
cannot
will not amount to injustice. Will it not amount to injustice?
That's what I said, right? Whether
Yes.
there's injustice or whether there's injustice or not happening, only the person who makes that gift knows better, because he knows the dynamics of his family members. We do not know. We are outsiders. We do not know. We can say, hey, you're doing injustice to others, but who are you to pass the judgment? Are you living with me?
I see.
Are you growing up with me? You're not. So you better keep quiet. So we tell that don't you judge yourself, because ultimately you're answerable in front of Allah. If you think that there are injustice to be done by giving away more than 70% of your property to whomever you want, right? If you think there's injustice, then you are answerable. If you think there's no injustice, right? I know that all my rightful beneficiaries, they are super rich people. Okay, they drive Ferrari, Porsche, Lamborghini, but then this is, I just married this very poor lady from Indonesia, right? I want to give her and her family members some money, right? And they are entitled for that. Is there injustice done or not? We're not sure. It might be the injustice, there might be no injustice. So, but if he thinks that there's no injustice done, then he must be brave enough to answer in front of Allah in the hereafter if he's being questioned.
I think in Hanafi laws is a bit different, right?
Yeah. This is from the Shafi'i law.
Yeah, so Hanafi laws, I think, doesn't allow that.
Yes. Correct. I'm talking from the Shafi'i point of view.
From the Shafi'i law point of view.
Is based on the Shafi'i.
Yeah, from the Shafi'i law point of view. Yes, correct. Yes, mashallah. Okay. Alhamdulillah. Okay.
Thank you, Ustaz. This now I got a little bit more clear picture. And then one more thing is okay, but maybe there, in addition, there may be something behind. Maybe that person, this donate person, maybe, or he have fulfilled all his compulsory requirement for his children or whatever. Maybe he have more than enough to feed the family, or he have something left behind. So extra one, he doing this thing according to his vow.
Okay. So yeah, again, it goes back to that person. He has to think for himself. I cannot answer.
Yeah.
I cannot
Then how
answer.
about the paternal and the maternal just now, regarding the ruling on the paternal and maternal side?
Yeah.
So maternal cannot get anything as long as the paternal is stay blocking.
No. It's different. It's different. I think Mr. Jamal can explain later on.
Please.
Because this is like I said just now, right? Between paternal and maternal, the one closest to the deceased will be maternal rather than paternal. Usually, the paternal is not as close to the deceased as the maternal, because maternal they grow up together. Paternal they are being raised by two different.
Okay.
So that is the difference in terms of closeness with the deceased, and that's about it lah. Okay.
You?
Yes, thanks.
MashaAllah. Okay. Any more questions? Walaikum salam.
My name is Naeem. Yeah, Ustaz Firdaus, thank you very much for this wonderful sharing. May Allah give you more barakah and tawfiq. You know, I've stayed in Singapore and I've become a Singaporean, and of course now I'm with a wife who is Malay. The question is, because I'm a Hanafi, I mean, I was brought up as a Hanafi. The question is, if I have the choice to, do I have the option to distribute based on Hanafi law? Although I'm a Singaporean and now I'm in, based on Sharia, we follow everything. But do I have that option to be distributing? Would I be using hiba or nuzuria as a method or technique? Which would be the most advisable, the best advice for me, without really going against the Sharia law?
All right, good question. Now, there is no difference in between Hanafi and Shafi with regards to the legal beneficiaries and the fractions that they will get. The same, 100%. Okay, the only difference is between the Sunni and the Shia. There's a very slight difference. The Ja'fari and the Sunnis. But the rest, nothing. Because it's very, very clear in the Quran and Hadith, no one disputes it. Okay?
Yes.
So the only difference is whether you can give 100% or not 100% of what you own. Okay. Now, it is safer. It is safer not to give 100% of what you own to anybody that you want. You give some of what you own, right, to whomever you want while you're still alive, because of charitable act that you want to do, and leave the rest for Faraid later on. Or you want to make a will, then limit it to just 1/3. So that is a safer way, right? There's no difference between all the four mazhabs on these sort of things.
I see. Thank you. Thank you, Sheikh.
Welcome.
Thank you.
Okay, any more questions? No, I think we are having the azan, I think, Maghrib.
Yes. Yeah, it's Maghrib already.
So everybody, thank you very much. Ustaz, Dr. Firdaus, you are really barakah for us. You are the highest level of the Jannah. So Alhamdulillah, you are the Firdaus also in the world. So that people will get benefit from your knowledge. Alhamdulillah, Allah has given you all this tawfiq to gain all this knowledge of the highest Islamic authority in fiqh and also in Sharia. Alhamdulillah, we are very fortunate to have you with us today. And then you have enlightened us in a short period of 1 hour time. The first topic, this is a very complicated, as you say, and also very complex mathematical, the mas'ala, this one. So you have enlightened us in a very simple and very easy way to understand. Alhamdulillah, this is Allah has sent you to us. And also maybe this is not the first time. We will continue to have you with us, inshallah, also bilateral, also in the gathering. Really, we are fortunate to know you and to know your address, to know what you are doing. It is very beneficial to our community. And then we only wanted this section to have the awareness to be revived among our community members, especially. You see, the people are really very forgetful of many things in Sharia. People say but do not practice. So to be able to practice, we need to know our Sharia, in our daily life. So this is our main objective. Alhamdulillah, it met. Thank you so much. Allah will give you barakah and tawfiq and give you very good health and live long life. Ameen, inshallah.
Thank you.
Inshallah. Ustaz Omar and Ustaz Firdaus, can you make a small dua for us? A short dua?
Ustaz Omar will be in a better position.
Ustaz
Omar Raja, Ustaz, the guest, a scholar who came to us, should make dua for us.
MashaAllah. Alhamdulillah.
So let us end with recitation of Surah Al-Fatiha. May Allah SWT bless our gathering today and bless the knowledge that we learn. May Allah SWT guide us to the correct path, and may Allah, avoid us from making any injustice to our property in this world.
MashaAllah.
Fatiha.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه.
آمين آمين آمين.
وجعل جمعنا هذا جمعا مرحوما وجعل تفرقنا من بعده تفرقا معصوما ولا تجعل فينا ولا منا ولا بيننا شقيا ولا مطرودا ولا محروما برحمتك يا أرحم الراحمين. ربنا آتنا وهيئ لنا من أمرنا رشدا وهيئ لنا من أمرنا رشدا وهيئ لنا من أمرنا رشدا. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. آمين. And let us end with the tasbih and